Please be seated. Good morning. The time set for an oral argument in cause number 22-0207, WEEMS versus State of Montana. Our counsel ready to proceed?
Yes, Your Honor.
Mr. Meade.
Mr. Chief Justice, may it please the Court. Brent Meade representing the State of Montana. I'd like to reserve 10 minutes for rebuttal. Like other medical procedures, the state may regulate who may perform abortions without infringing on a patient's right to receive a pre-viability abortion. Plaintiffs get it wrong when they suggest that the state doesn't have a role in setting such scope of practice rules. Weiser and Society of Anesthesiologists establish a clear rule that the legislature establishes a statutory framework concerning the scope of practice. The licensing boards, the Board of Nursing, Board of Medical Examiners, operate within that legislatively created framework. Weiser reaffirmed that such scope of practice rules are subject to rational basis, and that fundamental rights do not attach to seeking medical care from unlicensed providers. In this case, the district court correctly identified those foundational administrative law issues, but the district court got its conclusions wrong. The district court's error on those questions drove an incorrect legal analysis subjecting MCA 5020-109 to strict scrutiny. Under Weiser and Society of Anesthesiologists, the Board of Nursing lacks authority to issue licensing regulations contrary to statute. MCA 378103 sub 2 limits the board's authority by prohibiting a nursing license from being construed as a license to practice medicine or perform surgery. Consistent with the distinction between the practice of nursing and the practice of medicine, MCA 5020-109 authorizes physicians and physician assistants to perform abortions. And importantly, 5020-109 codifies the factual circumstances of this court's decision in Armstrong. The district court erred when it construed the general delegated authority in 378202 and the board's general licensing rule in ARM 24.159.1405 to override the specific statutory provisions in 5020-109 and 378103. This court must correct that error. Licensing boards don't possess an independent legislative power. They are created by the legislature and subject to legislative limitations. Finding otherwise allows the proverbial tail to wag the dog. Once the court corrects that issue, the remaining issue is the fact-dependent issue of provider availability. The record at this stage simply doesn't support a factual finding by this court that 5020-109 unconstitutionally impedes patient access to legal abortions. The record shows that 5020-109 authorizes over 8,000 physicians and physician assistants in Montana by virtue of their license to receive the skill and training necessary to perform legal abortions. That many or most of those 8,000 providers choose not to perform abortions does not place an affirmative obligation on the state to diminish its qualification standards. For example, in this case, Plaintiff Doe testified that she made the individual choice to leave Montana and no longer practice in Montana. That choice does not render Montana statute unconstitutional. And finally, the district court expressly declined to reach a factual finding on this issue. But as the state argued in briefing, the record is clear that there is no patient access issue. So turning back to what Weiser decided, it's important for the court to acknowledge that Weiser was a two-step process. There was a predecessor case in Chittenden in which the rule at issue was challenged as being outside of the Board of Dentistry's statutory authority. This court in Chitno said that no, the partial denture rule was consistent with the statute and that the Board of Dentistry was operating within its delegated authority. When Weiser came back up, the question was whether that rule was unconstitutional. And what this court did was say that there are two important components to Armstrong in paragraph 62. There's the question of whether a provider is competent to provide this service and whether that provider is also licensed to provide that service. The fundamental right does not attach if the provider is unlicensed. So here, it is clear that 5020-109 as well as 37-8-103 restrict the ability of nurses to provide abortions. They cannot be licensed to provide medical or surgical abortions. That's precisely the issue that this court dealt with in Weiser, that the competency is a secondary question to whether they are licensed. Because, as the court discussed in Weiser, what the other side is trying to do in this case is adopt a broad reading of Andrews that was cited in Armstrong, that competency alone triggers the fundamental right. And this court specifically rejected that reading of Andrews. Instead, this court adopted the logic of the Salmon case and the Manillo case. Salmon said that regulation of midwifery does not trigger a fundamental right. The Manillo case, which was an immediately post-Roe abortion case, said that physician-only laws do not trigger the fundamental right. And that distinction between the fundamental right of the patient to access a procedure and the scope of practice, that distinction makes sense. Scope of practice rules should be subject to rational basis. And that's for the reasons that this court very succinctly stated in Weiser at paragraph 18. If you subject scope of practice rules to strict scrutiny, then that places, as the court said, a very difficult, if not impossible, burden on the state to justify any medical qualification, not just the abortion procedure, but any medical licensing or qualification becomes virtually impossible for the state to adopt because the state has to show that no less restrictive set of qualifications serves the state's interest in protecting patient health. That proposition is what this court directly rejected in Weiser. Now, there below, and I think in the briefing, there was some dispute as to what the Board of Nursing said in its hearing minutes. Our position that's reflected in the record is that the Board of Nursing said, we are going to choose to leave the rules and statutes in place as they are. And that is, of course, how it has to be. The Board of Nursing lacks the authority to promulgate any rule that runs into conflict with its statutory framework. That if the Board of Nursing adopted an affirmative rule that APRNs can perform abortions, that would run into conflict with 5020-109 and 37-8-103. They do not have the power to adopt such a rule.
Is there anything in the board's minutes, or I don't know if it was recorded, that would suggest that that was the board's rationale for passing the motion it passed, that it was precluded from adopting a rule?
Your Honor, the state's position is that there's ambiguity in what they did. That as we said in briefing, that they said we're going to choose to leave the rules and statutes in place as they are, and the only proper way to read that is that they acted in accordance with their statutory parameters. That if you read that to mean that we're going to affirmatively adopt and allow the performance of abortion by nurses, that runs into conflict with their statutory authorization. That creates a MAPA problem that the administrative agency is acting outside of its delegated authority. And
doesn't their notes of it indicate that the medication and aspiration procedures aren't significantly different than the procedures of nurse practitioners that are currently perform those without significant issues? I mean, it's beyond just they didn't make a decision. They commented on the particular procedures being already part of what nurses do.
So, Your Honor, to that point, in the record, the state's expert witness, Dr. Mulcair-Jones, and I will point you as a way of example to Appendix C at 145, that the comparisons from these other procedures, such as IUD placement, to either a medication or surgical abortion, that analogy fails. And if you look at the guidelines from the National Abortion Federation, they require emergency procedures to be in place for abortions that are not required for other procedures such as IUD placement or removal. And that's because of the risks that are inherent in the abortion
But we're not
procedure.
talking about IUD placements, right? I mean, in the comparable procedures are things that like happen in miscarriages, which is you can use the same aspiration, procedure there, right? I mean, that's different than placing an IUD.
Your Honor, to that point, I would point you to Appendix R at 106, where, again, the state's expert, in this comparison between a surgical abortion or a surgical miscarriage, whatever similarities exist, they become slightly irrelevant because it's still surgery. And 37.8.103 operates to limit the nurse's license from performing surgery. That when we're talking about surgery, as we stated with the American College of Surgery thing, and as is found in Montana rule, surgery is the use of an instrument to alter tissue. And when we go through the descriptions of what is entailed in a surgical abortion, it is clearly and without question the use of instruments to remove tissue.
Isn't the same true of that procedure in a miscarriage?
Your Honor, again, that's why I would point you to the record at Appendix R at 106, where Dr. Jones is talking about the similarities between a surgical miscarriage and a surgical abortion. In both cases, it's surgery.
Mr. Mead, your reference to these appendices leads me to sort of a procedural question. The case comes to us on appeal from an order on summary judgment motions. Is there a factual dispute?
From the state's perspective, if for the plaintiff's motion for summary judgment that was granted, yes, there is a factual dispute about the risks in abortion and the similarities between these procedures and whether APRNs are competent to provide the service.
Counsel, nowhere in the state's brief is there any assertion that there's any genuine issue of material fact, or the district court erroneously concluded that there was no genuine issue of material fact. So what are you talking about when you say that today?
Your Honor, in the district court's order, I'd point you to the part where he's discussing the state interest.
I'm asking you about the arguments that you've already made to this court, and to what extent, A, that you even made such an argument, which I don't think that you did, and where in your briefing have you demonstrated the existence of a genuine issue of material fact on the summary judgment record as is required under Rule 56?
So, if Your Honor will excuse me for one moment, I'll get you. So, Your Honor, I would point you initially to the state's opening briefing at 43 when we're talking about whether 502109 survives strict scrutiny and the state's interest. And that is because the district court, in its order, found that...
What page? I'm sorry, counsel.
43.
Okay.
Because that relates back to the district court's order, and I'll get you the appendix site here in one moment. And so that relates to the district court's order, appendix A. It's on page 11 through 13, where the district court is diminishing the state's interest in protecting the health of the patient. That's what this relates back to, is the district court did not, when it was discussing the state's interest in protecting the health of the patient, the district court did not give full credit to the state's interest in protecting patient health. That's clearly in the record, and
Counsel,
we are
that's
clearly
a legal argument that is disputed between the parties here, clearly. But once again, when we just go back to basic litigation practice here under Rule 56, the state has not asserted, much less shown, in its briefing anyway, that there's a genuine issue of material fact on the summary judgment record that precluded summary judgment here. The state, to the contrary, is asserting simply that the court granted the wrong summary judgment. That's a pretty significant distinction, don't you think?
Yes, Your Honor, and to clarify that's because the state is asserting that 502109 is properly subject to rational basis, and on that standard, there is not a dispute of material fact that the state does have an established interest in patient health and that the law serves that legitimate end. That when we're framing it that way, yes, the state preserved the argument. On the strict scrutiny, I think it's clear from the factual disputes in how the two parties are describing these procedures that there is a difference of opinion between the parties. But for the state's purposes in briefing, this law is properly subject to rational basis under Weiser, and the record that we received, it clearly satisfies that standard. And I guess just to kind of put a fine point on that, I don't think that there is a material dispute on the risks to both surgical and medication abortion. That when we look at...
Well, shouldn't a question be framed in the context of not whether there's a risk to the procedure, but whether the risk is increased because of who is doing the procedure? And where's the evidence? I mean, there isn't anything in the record that suggests that there's more risk if other providers do the procedure.
So Your Honor, I have to disagree with that in the record, for example, again, the state's experts at Appendix C 187 to 189, and then specifically at C 138 and 139, Dr. Jones is talking about the risk of hemorrhage that is present in both medication and surgical abortion, and the need for the provider to have access to facilities capable of handling complications and also having the skill and competencies to deal with those complications that arise.
And that's the risk.
At C-139, Mulcair Jones specifically highlights this issue of the need for blood transfusions, that when he performs either a surgical miscarriage or a high-risk birth, he, as a physician, has access to blood transfusions within 20 minutes. When we go to the deposition of Nurse WEEMS, she is not affiliated with any hospital. She has never been affiliated with any hospital. That independent practice leads to a gap in the case of a complication in how to handle those complications that arise. And again, in her deposition, when in a surgical abortion, if there is a perforation that occurs and there is bleeding that occurs, her emergency procedure is in part to dial 911. Like, that is the risk that changes based on the provider.
Well, how is that different than when a PA does it, who doesn't have a doctor and is in the same clinic?
So, Your Honor, as we had in briefing, House Bill 737, the statute at issue here, one of the key underpinnings of the legislative rationale for that law was the existence of a supervision agreement between a physician and a physician assistant.
But we know from that doctors, that physicians aren't on staff all day long supervising PAs. Like, they do independent work, do these procedures independently, and there isn't that there.
I would point, Your Honor, to Appendix C at 47, where the legislature clearly looked at this issue and how PAs how they practice in rural areas. But what the existence of that supervision does is ultimately the physician is responsible for everything the PA does. That there is that agency relationship between the physician and the physician assistant that puts the physician on the hook for everything that happens under that supervision agreement.
Does that mean the PA won't be calling 911 in the outpatient situation?
Your Honor, what that means is that the procedures they have set up to handle the complications and emergencies, that professionally and legally falls on the physician.
Legally doesn't have anything to do with it when somebody is bleeding on the table. So your assertion is that these advanced practice nurse practitioners aren't qualified to do this, or that they are subjecting these patients to increased risk because in an outpatient situation, if there was such a complication, all they can do is call 911 and have these people transported to the ER. The court asks you the question, which you answered and acknowledged anyway, that the PA in that same situation is in that same situation. So what difference does it make that when it's all said and done after the fact, as far as risk to the patient, that the supervising physician is on the hook, as you say, legally?
So, Your Honor, I think I'll try to answer that by pointing you to Dr. Mulcair-Jones's deposition testimony at Appendix R at 106, that the state's expert testified that in his experience of providing high-risk births and surgical miscarriages for decades, that APRNs are not qualified through their competency or skill to perform these types of procedures.
But we're not doing a high-risk birth, right? I mean,
Your Honor,
which is dramatically different than a aspiration procedure or a miscarriage.
Your Honor, that's to illustrate the point that he is qualified to speak to these issues. That the state's expert, in his testimony, said that in his experience of working in this realm of reproductive health for decades, that APRNs do not possess the skill and competencies to perform these procedures.
Do PAs?
Your Honor, that was the choice of the Montana legislature with HB 737.
I'm not asking you about the legislature's choice. You're saying that the record is that these nurses, these advanced practice nurses, are not qualified to deal with these complications. Am I hearing that correctly?
Yes, Your Honor.
Okay, and I'm asking you, are PAs, who the legislature is authorizing to do this, are they qualified to do that?
Your Honor, with House Bill 737, the legislature made a choice that
I'm not asking you about the legislature's choice. I'm asking you about the medical evidence in the record.
The record in the evidence on this point is that the legislature was aware of that issue And because of the existence of the supervision agreement with the physician, they made the choice to expand the scope of practice for PAs to cover abortions under a valid supervision agreement utilization plan to enhance access for Montana patients, especially in rural areas. It was a conscious choice of the legislature to expand access like that. And again, when we turn back to Weiser and how this law should be viewed under a rational basis, that's a permissible choice of the legislature to draw that line.
It may be. That's the legal question. My question to you is an evidentiary question, and I guess we'll have to leave it at that.
And so, I guess, Your Honor, I do want to spend a couple minutes talking about understanding the other side's briefing, that there are factual distinctions between how this law came to be, House Bill 737, and how Armstrong came to be, the law question there. In Armstrong, prior to the statutory change in the 1990s, P.A. Cahill performed abortions since 1983 under a valid utilization plan. Her practice was what led to the statutory change. It was not the practice of anyone else in the state of Montana. It was P.A. Cahill's practice that led to that statutory change. And so when that came up on the preliminary injunction, that was a change in the status quo, that she had, prior to that statutory change, she had been performing this. Here, with House Bill 737, and I should also note that change in the 1990s, that was opposed almost unanimously by the medical community. With House Bill 737, this bill was brought at the request of the Montana Board of Medical Examiners, and it was supported unanimously by the medical community. And when we look at what the language in Armstrong hints at, that the legislature should be acting on the advice of the medical community, that's precisely what they did with House Bill 737. They took the advice from the Montana Board of Medical Examiners, they took the advice of the Montana Medical Association, they took the advice of the Montana Hospital Association, and enacted the package of changes found within House Bill 737.
But weren't those package of changes really directed just at PAs? Like, that was the purpose of, it was a PA thing. It wasn't really a broader discussion of, are there other providers that could do this?
That's right, Your Honor, but I will point out that the issue of the changes to 502109 and who can provide abortions were specifically debated in the committee record, and the legislature made the choice to codify the factual circumstances of Armstrong. It also did not target a practice in the same way that the Armstrong changes did. That 737 expanded the pool to include PAs and physicians. And as I stated earlier, that's consistent with this general distinction that our licensing statutes have between the practice of nursing and the practice of medicine or surgery. And a last point is that I want to discuss the consequences of the district court's order on the administrative law question about who can design this regulation. The district court said that the legislature has to defer to the Board of Nursing, that only the Board of Nursing can issue these scope of practice rules. As a principle, if the legislature lacks the authority to set a scope of practice rule, it can't delegate authority that it doesn't have. If the legislature doesn't have the power to establish a scope of practice rule for nursing, the Board of Nursing does not have the power to set a scope of practice rule for nurses. Perhaps that leaves this court as the state's medical licensing board, but I don't think that that's in the interest of the state.
That's not being suggested. That's not what the language that was quoted out of Armstrong says. The issue isn't the legislature's authority in the exercise of its police power, obviously it has that authority, as you point out, and as Justice Gray pointed out in her concurrence, as you point out in your brief, in Armstrong. The question is what is the impact of that on fundamental right, if any, and if there is, what's the legislative justification for that?
Sure. So returning to Weiser in paragraph 16 and paragraph 18 clearly subjects scope of practice rules to rational basis. So the impact to a fundamental right, as we suggest in our briefing, that would come if there is a hypothetical rule that restricts access to a legal procedure so severely that patients can no longer access the procedure. You know, that's similar to what the federal courts did in the post-Casey world, where there is a distinction between scope of practice rules and patient access to the procedure. And on that patient access to the procedure, the record demonstrates that Montanans continue to enjoy access to legal abortions. WEEMS herself acknowledges that abortions are available in Montana. There are other abortion providers in western Montana that perform both surgical and medication abortions. That question of access to the procedure is not at issue on this record. And because of Weiser's language, 50-20-109 has to be subject to rational basis, and the state has met that by showing the risk that is there within abortion procedures and drawing the line at we are going to allow physicians and those who work under the supervision of a physician to perform these procedures.
And that's through your physician witness?
Yes, Your Honor.
That's the only evidence that supports the rational basis?
Yes, Your Honor.
Okay.
And unless there are further questions, I'll reserve.
Ms. Schneller?
May it please the Court, Hillary Schneller with the Center for Reproductive Rights on behalf of Plaintiffs, Appellees. And with me at counsel table is my co-counsel, Alex Raitt from the ACLU of Montana, and our client, Helen WEEMS, is also in the courtroom this morning.
Counsel, could you pull your mic closer to you?
Sorry, of course. The state's central ask here is that this court not apply its controlling precedent in Armstrong. This court rejected that request once before when it affirmed the preliminary injunction in this case. The record is even stronger now. It reinforces that Armstrong controls for at least 4 reasons. First, the Board of Nursing has weighed in, as this court suggested it could and the state urged it had to. The board unanimously confirmed what plaintiffs have been arguing all along, that advanced practice nurses can provide abortion care and without specific authorization from the board. Second, like the law in Armstrong, the criminal statute here categorically prohibits patients from accessing abortion from a chosen provider, here nurse practitioners and nurse midwives, regardless of their education, training, and experience to provide it. It directly interferes with Montanans' fundamental rights to privacy, autonomy, and to access abortion from a chosen provider, rights the Montana Constitution affords the most stringent protection. Third, the record is now fully developed after years of discovery, including depositions of the plaintiffs, their experts, and the state's experts. With every opportunity to demonstrate otherwise, the state has no credible evidence that restricting the provision of abortion to physicians and physician assistants only is necessary to advance a compelling health interest, let alone in a narrowly tailored way.
Counsel, so that was my question, the last question. and I asked specifically what was the evidence that the state had, and the response was the physician Montclair, I can't remember.
Dr. Melchior-Joe.
Yes. So can you address that aspect of the state's response?
So maybe it will be helpful to turn to the record. I mean, the record is undisputed that medication and aspiration abortion safety do not depend on whether a physician assistant, or advanced practice nurse is providing that care.
That is undisputed.
Correct. And that is based on testimony provided by our expert based on several studies, including a 2013 study in the American Journal of Public Health. The state may disagree with that, but it has not come forward with actual evidence to show that abortions provided by physicians and physician assistants result in any different safety than those provided by nurse practitioners and nurse midwives. And the fourth point I wanted to make about the difference in the record between when this case was before this court before and now is that Ms. Weems has in fact been providing abortion care without issue with this injunction in place. So based on the robust record before it, the court was correct to find the criminal statute unconstitutional. That order restored Montanans' fundamental rights to access abortion from a chosen provider and with a chosen provider who has the requisite training, education, and experience to provide it. As a practical matter, despite the state's dramatic protestations, all the district court's order does is say that abortion is treated like other care, and specifically like miscarriage care, which the state concedes advanced practice nurses can provide, and its experts agree is the same as abortion care. So the district court's order was correct. It follows the facts and precedent, and this court should affirm.
Excuse me, is there a factual dispute about that last point? Mr. Mead gave a number of references to the record that indicated that the state's experts dispute that the ability to handle it as safely as a miscarriage, that it's the same.
So the state's experts conceded that miscarriage care and abortion care are identical in several places, which we have cited in our brief and from their deposition testimony, noting that treatments and protocols for abortion and miscarriage are identical, and what follows is that the skills to handle those would be the same. So there is no dispute in the record on that fact. Additionally, it is undisputed, as I mentioned, that medication and aspiration abortion safety do not depend on whether a physician assistant, or advanced practice nurses can provide abortion. Third, the state here urged the Board of Nursing to weigh in, and it confirmed that advanced practice nurses can provide abortion consistent with its rules and without additional specific authorization. As was noted earlier, the board went further, stating that medication and aspiration abortion are similar to procedures and medications advanced practice nurses already provide. So, as the district court said, the only fair reading of that is agreement that the criminal statute here is not based on an advanced practice nurse's qualifications. Additionally, the board's statement is consistent with the broader medical community, with standards of national nursing professional organizations the board recognizes, and leading public health and health professional organizations which agree that advanced practice nurses can provide abortion. And finally, there is no dispute that the board's rules apply to advanced practice nurses, and there's no evidence that advanced practice nurses are unable to follow those rules, including with respect to abortion. Much of the state's argument here boils down to a disagreement with the Board of Nursing, but the board didn't do anything but weigh in at the state's urging. As we showed at the preliminary injunction stage and again on summary judgment, looking at the Nurse Practice Act, the board's rules and its practice standards, as well as the consensus in the medical community, advanced practice nurses can provide abortion consistent with their education, training, and experience. And so they fall within the ambit of providers to whom Armstrong says Montanans have a fundamental right to access abortion care. The board here affirmatively confirmed that to remove any remaining doubt.
Counsel, in the briefing, much is made by the state, at least among other things, about this idea that this reference to self-assessment in relation to the standard of practice to, at least as I read it, imply that advanced practice nurse practitioners basically define what their own scope of practice is. Is that the way it is?
No, that's not correct. So as the district court noted, the way nurses determine whether something is within their scope of practice is by reference to their credential, right? Nurse practitioner, family nurse practitioner, or nurse midwife, as well as national nursing professional organizations which define the details of scope of practice that is set in the board's rules. And I guess I would comment that self-assessment is actually quite common across health professions.
What does it refer to?
It refers to the advanced practice nurse as a result of her license being trusted to rely on her education as well as the standards of her national professional organizations to say, do I have the training and experience to provide this particular service? Just like a physician would determine based on his education, training, and experience whether he can provide abortion, right? For example, the Board of Medical Examiners doesn't have a comprehensive list of procedures and medications each physician can provide. It trusts that a cardiologist is not going to provide abortion care if he doesn't have the education, training, and experience to provide it. A cardiac surgeon isn't going to perform neurosurgery, and so on. That self-assessment is common across health professions, and the boards of medical examiners or the Board of Nursing have disciplinary power if an advanced practice nurse, if a physician provides care beyond their competence, if they've made the wrong assessment. Does that answer your question?
It does.
Yeah, okay.
Thank you.
I wanted to spend a minute on Weiser, which the state speaks about in a great deal, but Weiser really accepts Armstrong's holding and confirms that it controls here. Weiser rejected a fundamental right to access health care free of regulation or from a provider who was not licensed or competent to provide it. But it quoted Armstrong as defining the fundamental right as a right to a chosen provider who has been licensed and is competent to provide the particular service as defined by the medical community, which we have shown here. Additionally, Weiser sort of answers the question the state presses here about the relationship between general police power and setting scope of practice and fundamental rights. It acknowledges that the state has a role in regulating for the safety and health of its residents, and that the exercise of that power often implicates individual rights. But it says when the rights affected are not fundamental, the court does not apply strict scrutiny. Here, because the right affected is fundamental, strict scrutiny does apply. So as this court held in WEEMS 1, Armstrong controls, and the district court correctly applied that controlling precedent to find that the criminal statute interferes with the fundamental right, just in the way the criminal statute in Armstrong interfered with the fundamental right. It categorically bars Montanans from accessing abortion from a chosen provider who has been determined by the medical community to be competent to provide abortion care. When the state does address the fundamental rights and strict scrutiny issue, it says that because the law here does not ban abortion, it does not interfere with the fundamental right. And of course, that's incorrect. Under Armstrong, Armstrong made clear the right is not so narrow. It encompasses individuals' rights to access abortion from a chosen provider. Indeed, in Armstrong, physician assistant HELEN, Dr. Armstrong provided in the same clinic. Barring patients from accessing abortion from a chosen provider, was enough to interfere with the right. And that is because Armstrong recognized that the right to seek and obtain abortion is at the intersection of a medical judgment impacting one's bodily integrity as well as reproductive and personal autonomy, and that medical decisions must often and necessarily be made in partnership with a healthcare provider. And so it is critical that the individual has control over who that provider is to fully effectuate their right to make this decision and to access care. The district court was also correct to find that the statute fails to meet strict scrutiny. The state had a high burden here. It had to show that barring nurse midwives and nurse practitioners from providing abortion averts a medically acknowledged bona fide health risk, and it absolutely failed to make that showing. First, again, it failed to show any reason, let alone a compelling one, to justify prohibiting people from accessing abortion but not miscarriage care from an advanced practice nurse. Second, as the district court found, medication and aspiration abortion safety is the same between advanced practice nurses, physicians, and physician assistants. As the district court noted, every alleged risk the state cited had nothing to do with whether a provider is a licensed physician, or advanced practice registered nurse. I'll also note that the criminal statute here bars advanced practice nurses from providing abortion care, but nothing in the criminal statute bars an APRN from treating a complication a patient may have experienced, including a complication they may experience after a physician has provided abortion care. Next, the state's emphasis again on physician and physician assistant supervision.
I'm sorry to interrupt, Ms. Schneller, but that gets back to the point Mr. Mead was making about if it is a physician, the physician has immediate 20-minute access to hospital care, blood transfusions, and that sort of thing, whereas an APRN would not have that kind of access. Can you address that as a factual difference in the record you're referring to?
Sure. So as the district court noted, I think that all has much more to do with the setting in which abortion care is provided. So a physician providing in an outpatient clinic would have access to the same equipment, staffing, et cetera, as an advanced practice nurse. It's not about the credential, the clinician's credential. It is more about the setting in which care is provided, and Montana does not restrict the provision of abortion to hospitals or outpatient surgery centers. It permits abortions to be provided in clinicians' offices, whether by a physician or an advanced practice nurse. So I think that the point the state is making sort of doesn't impact, is unrelated to the provider who is providing care. Yeah.
Miller, excuse me, but has you're relying on Armstrong in terms of the standard of review? Is that correct?
Yes.
Has Dobbs changed the field at all in terms of the equation?
I'd say no for a few reasons. First, of course, no party in this case has raised Dobbs, so I just want to note that. But in addition, of course,
well, and I'm talking. Excuse me for interrupting, but I'm talking about in terms of how close the issue between access and the right, which Armstrong makes that connection, but I'm not sure some of the language in the Dobbs decision might make that more tenuous, that connection.
So I would say for this court interpreting the Montana Constitution, what the U.S. Supreme Court has said about Roe and the 14th Amendment protection or lack thereof for abortion has no bearing on this court's interpretation of the Montana Constitution. I think that is particularly true where this state's constitution has an explicit protection for privacy, and this court has said it is the most stringent protection for privacy, including in a case, Stand Up Montana. This court referenced Armstrong in an August 2022 decision, right? So post Dobbs, continuing to state that protection remains the most stringent. So I think there are several reasons of why the U.S. Supreme Court's decision in Dobbs does not impact this court's understanding of its own constitution. Does that answer your question?
Well, not directly, but it's not a question of abortion or no abortion. It's a question of access. And people in Montana still have access to abortions. So I guess, and that does, I think, have some implication on the standard of review.
So I would say that Armstrong made clear that the right to access abortion from a chosen healthcare provider was not dependent on sort of the statewide provider availability. As I mentioned, Dr. Armstrong and physician assistant Cahill were providing in the same clinic. The evidence in that case was that patients might have to wait 45 minutes to see Dr. Armstrong instead of physician assistant Cahill if she wasn't able to provide those services. So I think here the critical issue is whether you have access to your chosen provider, not whether you would necessarily have to travel many miles, for that care, which has been more of an issue in the federal jurisprudence before Dobbs.
Okay, thank you.
Turning back to strict scrutiny and the compelling health interest, the state has mentioned the physician and physician assistant supervision issue as compared to advanced practice nurses' independent practice. But the state has not shown that physician-assistant supervisory relationship is critical to safe abortion care. Again, as the undisputed evidence shows, medication and aspiration abortion safety are equivalent regardless of whether the clinician is a physician, physician assistant, or advanced practice nurse. And finally, again, absent the criminal statute, the board's rules continue to apply, and there is no evidence that advanced practice nurses cannot abide by those rules, including when it comes to abortion. The district court also correctly found that the criminal statute here is not narrowly tailored, and for good reason, categorically barring Montanans from accessing abortion from a qualified nurse practitioner or nurse midwife is not the least intrusive way for the state to advance its interests. For instance, if the law is meant to protect health, it is under-inclusive because, again, it singles out abortion care but does not apply to miscarriage care. And if it is meant to protect people in underserved areas, it is over-inclusive as it applies regardless of a patient or provider's proximity to additional levels of care. And it imposes criminal penalties on advanced practice nurses who do have the education, training, and experience to provide abortion care, but not on physicians or physician assistants who might provide that care without such qualifications. I wanted to also briefly address the state's statements about HB 737 and its legislative history. So first, I just note that the intent of that legislation is really not relevant here. Whatever the intent, the criminal statute remains deficient and out of conformance with Armstrong with respect to providers other than physician assistants or physicians or physician assistants. Second, the state is really just wrong about the intent behind HB 737. I think, as is clear in looking at the full bill, the legislation meant to update 30 sections across the Montana Code relating to physician assistants. It really didn't have anything to do with abortion other than updating the physician assistant bar on providing abortion care because that had to do with physician assistants. There's certainly no indication in the legislative history that there was an affirmative decision to prohibit other practitioners from providing abortion care. And finally, I think the state is just wrong about the impact of HB 737. It didn't actually expand who could provide abortion care. Between this court's decision in Armstrong in 1999 and 2005, when that legislation passed, healthcare providers who were competent to provide abortion care could provide it, whether they were physicians, PAs, or advanced practice nurses. HB 737 restricted that pool of providers, again, back to only physicians and physician assistants. So to sum up, if the court doesn't have further questions, there's really no good reason, let alone a compelling one here, to let this criminal statute stand. In granting summary judgment, the district court simply followed the facts and precedent here. And to rule for the state, this court would have to make new law. To affirm, all this court would be doing is applying Armstrong and WEEMS 1, and we'd ask the court to affirm.
I do have one follow-up question on your last point about the impact of the bill after Armstrong. Is there any evidence, is there anything in the record that shows that providers other than PAs and physicians were performing this service prior to passage of HB 737?
I am not aware of anything, and I don't believe there's anything in the record on that.
Counsel, so kind of in follow-up on that, what about between 2005, when the statute was enacted, and before there was a substantial period of years before the preliminary injunction was issued by the district court, in terms of access? Because then you had a period of time there where nurse practitioners were prohibited before the statute was challenged. What was the impact to access during that period?
Well, the impact was that only physicians and physician assistants could provide abortion care. There have been a limited number of clinics in this state for many years, but again, I don't think that's, I may not be answering your question.
Well, I guess I'm just, maybe I'm just asking Justice Baker's question another way. So prior to were there nurse practitioners, I guess, that stopped practicing and then resumed practice? I mean, we have obviously the plaintiffs here, but were there nurse practitioners who stopped practicing, which would, upon the passage of the statute in 2005, which would seem to indicate a reduction in access, but then resumed practicing? So I guess I'm trying to compare pre-2005 with post-preliminary injunction.
Right, I am not aware that between 2005 and before we filed this case, there were other nurse practitioners or nurse midwives who had sought to provide or who were stopped from providing as a result of that 2005 legislation, but they would have been, right, had there been people providing in that interim years, that this 2005 legislation would have prevented them from doing so and would have been a regression from Armstrong.
You're just not aware of any, like there could be some, but you're just not aware, or you think there weren't any?
I am not aware either way, and the record doesn't speak to that.
Counsel, let me ask something about the district court's decision. In striking down the statute, the court employed a rationale to the effect that this decision was a decision of the board and not the legislature. The district court reasoned that because of Armstrong, the legislature was not better able to make the decision, and the court found that the Montana Board of Nursing to be the appropriate source of authority for determining competency to provide abortion procedures. And your brief kind of adds on to that idea, page 24, in which you state that the state's police power here was exercised through the board and not the legislature. My question is going to be what you think about that rationale, because I do think there is a difference between, on the one hand, saying to the legislature, you have the right to legislate in this area of abortion. If you get it wrong, it could be struck down as constitutional. And on the other hand, saying, legislature, you don't even have the right to legislate on this subject because that is the exclusive jurisdiction of the board. Did the district court get that right or wrong?
I mean, I think the district court was applying Armstrong, which said that people have a right to access abortion from providers who the medical community acting through the boards deem competent. And the criminal statute here really isn't about the board's authority or really isn't about scope of practice or competence. If it had been, Armstrong would have been over before it began, because the criminal statute would have answered all of those questions. And I think Justice Gray's concurrence in Armstrong kind of clarifies this a bit too, that yes, the legislature has a role here. It sets up general practice acts, as it has done here with the Nurse Practice Act, and a board to implement it. But once it has done that, it can't indirectly intrude on the standards that the board it has created has set. That is sort of that is where it goes too far.
So once the legislature creates a board and delegates the responsibility to it, it has no further ability to legislate in that area?
I think there may be ways in which the legislature can certainly regulate generally, but here their legislation has targeted and implicated a fundamental right, which moves this into a different, into a strict scrutiny realm.
That's a different question than saying the legislature has no right to legislate in this area. That's a completely different question, correct?
Yes, and the legislature certainly has legislated in this area by creating general licensing schemes.
Counsel, to follow up on that, I mean, it seems to me, just to call a spade here, the district court got that wrong. The legislature has that power, but the real issue in the case is what is the rationale for the legislature's conduct or action if there's an impact on this fundamental right. Isn't that not where the case is at? Because there's a danger here that this case gets sidetracked into this discussion and debate, which to me is a closed question as to whether the legislature can regulate the medical practice. It can.
Yes, I think that's correct. I think all the district court was trying to do was follow what this court said in Armstrong as well as WEEMS 1, which indicated an interest in what the board had to say here about whether advanced practice nurses can provide abortion care. And we had shown clearly that there is a consensus in the medical community that they can. The board's action here removed all doubt, and I think that the district court was focusing on that board's additional clarification that, in fact, consistent with its standards, advanced practice nurses can provide abortion care.
Which is the same thing that Justice Gray was commenting on, because the language was too loose in Armstrong in that regard. Isn't that a fair characterization of that?
I think that's what Justice Gray was getting at, yes. But I think it's important to keep in mind that Armstrong was setting up, was interpreting the scope of a fundamental right, that this was not just about decisions, medical care decisions, but these medical decisions bear on personal and reproductive autonomy, and so there is a different standard that needs to be applied given the intense interests at stake there. Thank you.
Thank you, Ms. Schneller. Mr. Mead.
Thank you, Your Honor. I want to start by addressing that last line of questions and be clear on what the state's asking this court to do. We are asking this court to reverse the district court on those two foundational administrative law issues that were identified. Who sets the scope of practice, and what's the Board of Nursing's authority on that? And applying wiser correctly in that circumstance would subject 50-2109 to rational basis. That we would then ask this court to remand this case back down, because similar to wiser, where the district court reviewed the statute under strict scrutiny, this court remanded for a determination under rational basis which had not been considered. The district court did not review the statute under rational basis, so I believe remand on that question would be appropriate. So again, consistent with Armstrong, Weiser, reverse and clearly reverse on the administrative law questions about who gets to set scope of practice, that because the legislature established a scope of practice rule, the Board of Nursing can't go beyond it, the statute is viewed under rational basis, and remand for consideration under rational basis.
So I may be getting off base here, but so are you basically arguing that anytime the legislature sets up a regulatory body or sub-agency to monitor something or set rules and standards, the legislature then can go in and enact whatever they want with regard to any particular standard, or and that the governing body that they set up to oversee it would have no authority then to look at it differently?
Your Honor, from the state's perspective, it's that the administrative agency that's established by the legislature can't go beyond what the legislature has delegated to it, so that necessarily entails the ability for the legislature to set limitations.
Here they delegate the scope of practice to the Board of Nursing?
Yes, Your Honor.
And so, let's look at, they do the same with DEQ and things like that. So can we just then have the legislature pass a particular statute that just changes like discharge regulations or something like that for streams? And is that what you're suggesting the legislature will be doing? Or has the authority to do then?
Your Honor, I guess I would point you to Weiser and its predecessor case, Chitno, where the legislature did set an express limitation on the ability of denturists to practice in Montana. That it was, in that case, the statute and the rule operated in concert to provide a limitation on the scope of practice for denturists. And because denturists were not licensed, that's where the court in Weiser drew that division between scope of practice rules and regulations that impede patient access. And scope of practice rules are presumptively viewed under rational basis under the logic of Weiser, because Weiser considered the argument that we've heard today that if the medical community believes itself competent, that that's good enough. But Weiser set two operative limitations in place. There is, of course, the competency component, and there is also the licensure component. That irrespective of that competency determination, there is not a right to practice medicine. There is not, the fundamental right does not attach to seeking medical care from unlicensed providers. And that's in Weiser paragraphs 16 and 18 when they discuss the Andrews case and distinguishing Andrews, and instead going to what I believe the Third Circuit said in Salmon.
Do they have a fundamental right then to seek the medical access to care from licensed providers?
Your Honor, I believe that that's a fair reading of Armstrong, that the fundamental right attaches to seeking a lawful procedure from a licensed and competent professional. And so in this case, that's not really an issue because, as Nurse Weems acknowledges, there is access to legal abortions in Montana. It might not be through Nurse Weems' practice, but you can go to Blue Mountain Clinic, for example, to receive aspiration or medication abortion. That there are qualified licensed providers who provide these services in Montana. In that access question, on this record, it's not disputed that there is access to legal abortion in Montana. And I want to turn to, there were questions about Nurse Weems' training. So I want to quickly move to a couple points in the record. So in the record at Appendix C218 and then C221, Nurse Weems' self-certification to perform abortion is a completion of about a 180-page workbook. She completes this workbook in consultation with what are called mentors. The record is unclear as to who these individuals are. But what is clear at 221 is that she does not submit proof to the Board of Nursing that she has completed this workbook.
Is there any evidence that she's practicing outside the scope of her authorized practice by the Board of Nursing?
Your Honor,
Yes or
If-
no?
under the statutes, yes. That 50-20-109
Under
says,
your argument,
and then under 37-8-103, there's the additional limitation that nurses cannot perform surgery or
that
practice
means
medicine.
nothing if those statutes are invalid, does it not?
If they are enjoined, that's probably correct, but there's, an argument that's not here but would be for another day.
Counsel, I had a question about 37-8-103. When you talk about practicing medicine, there's no, that does not preclude APRNs from prescribing medications, correct?
That's correct. The nurse prescription statute says that they can only prescribe medications in conformance with other state and federal law and regulations. So in this case, the operative other state law is 50-20-109.
So 37-8-103 of its own, standing on its own, does not foreclose the prescribing of medications.
Not the prescribing of medications, but the prescribing of abortion medications, yes, because as we say in briefing, the risks between surgical and medication abortion are very similar in that it's internal bleeding, it's hemorrhage, and it can possibly lead to patient death. And
There's risk with the prescribing of a lot of medications.
well, Your Honor, I would point you to the record at C-283 when the plaintiff's expert said medication abortion includes bleeding, infection, failure to complete the abortion, and the possible need for a procedural intervention, and rarely patient death. And that's why the National Federation of Abortion guidelines say that if you are going to prescribe medication abortion, you also need to be qualified to perform surgical abortion because of that possibility of needing a procedural intervention. And so I just want to finish up very quickly on Nurse WEEMS' training. When you turn to C-233, her view of self-assessment is that if there is no overt rule against a procedure and she believes that she is capable of providing it, then she knows it's within her scope of practice. So if you take that testimony in tandem, the failure to submit proof of completing this work along with the self-assessment of her own skills, that's why the state calls this, it is self-certification of her ability, and that's why the state has the ability to go in and regulate. Thank you, Your Honors. If there are no further questions.
Thank you to both counsel and the counsel on the briefs, including the amicus. It's appreciated. Court will take this matter under advisement and issue an order of opinion in due course.